Gavrilovic, Research Assistant at the Cyberjustice Laboratory at the University of Montreal. For today's webinar, we welcome Guillem Soler, Judge of the First Instance Tribunal of Barcelona. He will give a presentation on the technological challenges in pandemic times and for the future, and then we will ask him the questions that we have received from the audience at the end of his presentation. On this note, I give the mic to you, Judge.
First of all, thank you to the Laboratory of Cyberjustice for inviting me to share my experience and thoughts regarding the current situation. You asked me to present myself, so that's what I'm gonna do right now. I'm, as you said, Guillem Soler. I'm a judge working in Barcelona in a tribunal as first instance in Barcelona, number one, and I deal with civil cases. It's not criminal, not family cases, only civil, contractual, and this kind of cases. I've been working since more or less 18 years as a judge, and I could say, I may say that I am kind of specialized in consumer law, especially in mortgage loans or rental procedures, this kind of contracts. And the reason why I'm right now here is, I'll explain a little bit. It's for 4 or 5 months, I began to be interested in technological issues in relation to their application to the judiciary, in a broad sense, from artificial intelligence and other kinds of digitization. That's why I contact the laboratory to see if there could be some kind of sharing or collaboration, and this end up with this webinar for the moment. So again, I thank you for this opportunity. I think it's enough for my presentation, and today, right now, I will try to share my document. I prepared this one. Yes. First of all, I would like to begin with some pictures. The first one are quite scary ones, but it's the reality. Let's see if we can see them. Yes. Here we have a photo taken in a Spanish courtroom. That was in the first weeks of the pandemic. So I think that not quite reason and some kind of precipitated measures in a rush. Someone had this not so brilliant idea of put all these plastics in the courtroom. When I saw these pictures, I was really scared. I thought if when I'm coming back to work, I have to deal with this kind of plastic, I don't know how it will work. Here we have another quite more polite plastic, but a plastic the same. So this one these are some of the first measures. I'm not quite sure if this kind of plastic measures, first of all, I don't think you can call it high tech, but I'm not sure if they have remained so. Perhaps finally they decided not to use this kind of plastic. Here we have this is a more recent paper addressed to the lawyers in a court, in a tribunal. Is from this week or 2 weeks ago. Here the officials of the tribunal addressed to the lawyers and ask. I've translated the suggestion. Ask the lawyers to, in the sense that it is forbidden to use saliva to lead through the file. That would be another non-high-tech measure. And I would say 2 things. First of all, it's not high-tech, and second, curiously enough, it is addressed only to the male lawyers, not to the female. So I'm not quite sure if the female lawyers are allowed to use saliva to lead through the file, or if we are only facing a sexist use of language. So here we have some, we could say, bad news about the measures taken in Spain courts, but not all are bad news. Here we have a recent hearing from this week or the last week, a recent hearing in which it's from a tribunal from a city called Hospitalet de Llobregat that is quite near Barcelona. It's very near from Barcelona. Here we can see a judge sit on the courtroom, and in the screen we may see the face of a woman. Is a lawyer, and this is a preliminary hearing in a civil case that has been held by videoconferencing. We are going to talk about that, but I would like to point out right now from the beginning that in this case only lawyers and professionals participated in this hearing. So there is as we will see later, there is a huge difference, I think, between a hearing or trial in which only professionals participate and other ones in which we have to we have proof, witnesses, experts, and so on. There are a lot of differences. So let's move on. Here, the last one. Here's it's I would say a good one. Plastic protection for the micro in the courtroom. So here we can see the three parts. I will divide my talk in three main parts, although they are quite related to each other. First of all, I would like to talk about some short-term measures that have been taken in the judiciary and Spanish judiciary facing the pandemic. I can say right now that I'm afraid that they are not quite different from the measures taken in other countries. The second part of my talk, I will focus on the video conferencing. That is clearly the king measure, king technological measure during the pandemic in the judiciary, not only in Spain but also in a lot of other countries. These are the points I would like to address. And the third part, it will be possible suggested improvements for the future in terms of digitization or more advanced video conferencing, and even some remarks regarding possible tools of artificial intelligence tools. These are going to be the three parts of my talk. Nonetheless, I would like to first of all to make some general remarks that I think they are quite obvious, but it's absolutely necessary to keep them in mind permanently when facing this kind of issues, because we are talking of the judiciary. What is the judiciary? It has special features, quite special features that make it more difficult, or not more difficult, not necessarily more difficult, but specific to apply to the acts of the judiciary, certain new measures. We have to be very careful. Why? First of all, because it is, of course, a public service, but a special one, a special public service. Because at the same time, simultaneously, and I think that's what it makes it so particular, it is a power of the state. It is one of the three powers of the state: the government, the legislative, and the judiciary. And its main function, among others, is to decide over fundamental rights of people. And not only that, because it does this in a very specific way. Mandatory is a mandatory last resource. The citizens are obliged, in the end, to go to the courts to ask for their rights to be protected. Of course, they can go, and it's a great idea to go to other ways to resolve their conflicts, as negotiation, mediation, arbitration, online resolution, dispute resolution. But in the end, if you have no solution to your problem, you have to go. The last resource you can and must go is the judiciary. And the second is that what the judiciary decides is enforceable. So that's why precisely it's so important how is it decided? I mean, how the judiciary make their decisions. Here is important the procedure. In this procedure, we have to respect, of course, the rule of law, the due process, the right of offense, and a lot of other issues. So if we want to apply some new technological measures to the judicial procedure, we have to keep in mind all these requirements. At the same time, when the judiciary decides, it's important that it decides in proper time with reasonable delays, not 5 or 6 years later after the claim is is filed in the tribunal. So we need to achieve a balance between efficiency and the respect for rights and traditional legal principles. It is within this dilemma that we have to ask ourselves which role could technology play in this dilemma. If we are really facing a dilemma, we are going to look at this. So this was an introduction, but I think it's quite important to keep in mind all that has been said. Right now, I will enter into the questions of the talk. Here, I think there is another quite important difference. I think we should distinguish quite clearly when we talk about technology and judiciary between different levels of technology, of implementation of technology. First of all, the digitization. We would say the judicial procedure goes from the paper to bits, ones and zero. This would be one level of technological process. The second level, it would be the video conferencing. That's to say, from in-person hearing trials to remote procedural act. We'll see that the problems, the issue that arise in these two kinds of technological venues or channels are quite different. And the same can be said in respect to the third level, that is artificial intelligence applied to the judiciary. We could say from human decision-making to automation. So here we have three main fields where we can apply new technology to the judiciary, but they are quite different. At the same time, they may get related and integrated in some kind of umbrella platform, as we see later. But we have to keep in mind that they are quite different and they must be addressed also from different perspectives. So let's talk about the first part of the talk, with more precise perspective, the judiciary facing the pandemic. In this case, I think, especially for what has been the experience here in Spain and Spain judicial system, it's absolutely crucial to make a difference between what has happened in the case management proceeding. To make it clear, we could say the paperwork to make the procedure advance even before any kind of hearing or trial. That's one problem we have had to address. And the second one are the trials and hearings themselves that, of course, have been addressed also, but with other kind of problems. If we focus ourselves in the first aspect, the case management procedures, the paperwork, I think that I'm sure, I'm afraid that there would be the same, quite the same in all countries, but there is a chain in the procedure, in the paperwork. First of all, the officials of the tribunal, from the filing of the claim, the admission of the claim, the summon, or sending of the claim to the other party. In this case, there is work for the officials of the tribunal, the clerk of the tribunal, and finally intervenes the judge. So here we've got the main problem, of course, has been the lock and the close of the judicial buildings. So there was only one chance. In general, I'm speaking in general, not in the urgent cases. They are different, but in general, it was only possible to work by teleworking. And for that, it is essential to have at our disposal a VPN, or virtual private network, or any other kind of technological system that allows to have a secure connection to another network over the internet. Of course, if you don't have so, the judge, the clerk, cannot work from home in a proper way. So the problem that we have had here in Spain is that while the clerk and the judge had laptops with proper VPN, virtual private networks, it was not the same with the officials of the tribunals. So it has not been possible to make the procedures advance, even without any hearing. So that has led us to a certain kind of paralyzation of the procedures, even before the trials or the hearings. That has been a big problem. So in the future, I hope it's not the case, but if there is another pandemic or another situation like the current one, it is crucial for the officials to have at their disposal a VPN, a laptop, or similar. Let's move on. If we focus on trials and hearings, of course, the major part of them have been deferred or suspended, and only the urgent cases, have been celebrated by, of course, in some case, video conferencing, and in other case, with in-person trials and hearings. Of course, I think it's similar in all the countries. In criminal jurisdiction, we have considered urgent cases those in which there were detained or in custody person accused, or trials in which the accused was in preliminary detention. I mean, the first one, sorry, detained or in custody person, it meant police detention. Of course, before the judge decides if they have to remain in preliminary detention or to set free. So there has to be a hearing, and those hearings, of course, are urgent. In the civil jurisdiction, is the one in which I work and know better, the family cases have been considered urgent, and also precautionary measures or provisional remedies in the case of the general civil jurisdiction. There have been other special legal measures during the pandemic. Those ones that have been approved, that are into force right now, besides the suspension or stay of terms, deadlines, and non-urgent trials, there have been a specific a law that states that the telephonic and telematic communication is preferred. in the trials and hearings, there is a priority to video conferencing, of course. There has been a waiver or dispensation to the lawyers of wearing the rope for obvious reasons. And other measures that I'm afraid the judges in general are not quite happy with them, but trials in the afternoon and trials in August. In respect to the trials in the afternoon, right now there are some doubts because there are labor rights of the officials of the tribunals involved. It's not quite sure that it is going to be able to hold these trials in the afternoon due to labor rights of the official tribunals issues. We'll see if that's possible, final possible. There are other measures that they were intended but not finally not approved, and I think it's a wise decision because right now we are in a hurry and there is a danger to pretend or to try to make a big reform of the civil procedure, and I don't think it's the right moment right now to address this kind of important reform. We need more time. So it was intended in the first moment to eliminate some oral hearings in certain civil proceedings, and even to eliminate the right to challenge the ruling in certain proceedings. All that, of course, in order to speed the proceeding. But in the end, these ideas have not prevailed, and I insist. I think it's a good reason, a good decision. Finally, not surprisingly, the budget of the measures taken in the judiciary, I would say, has been of €0, as it is usual in this area. We are used in the judiciary to not be granted so big, quite big budgets for the reforms. That's one of the problems that have led us to this situation. Finally, I've put here the date in which we have had the resume of the judicial activity. It has been the general resume of the judicial activity. It has been the 4th of June last week. Let's move on. Right now, I would like to go deeper and asking ourselves some questions. The first one is the following. Are the technological measures undertaken during the pandemic or if its aftermath only ad hoc measures to be enforced while this exceptional situation remains, or on the contrary, are they supposed to remain to, in the end, integrate in our judicial system? That's the question we have to face. Even beyond these measures, there are other possible improvements for the future we haven't had time to think of or to implement. Which one? These are the kind of things I want to address. First of all, we have to distinguish, of course, the urgent and circumstantial needs generated by the pandemic. Of course, the judiciary is an essential public service, and we have to render the urgent cases. So here there have been some urgent circumstantial needs to be attended, but we have to distinguish them from the structural and general needs of the judiciary. It's an obvious distinction, but an important one. And especially, we don't have to devaluate the due process of law in the search for speed and simplicity. We have to reach a balance. How can we reach this balance? Here, I've put a quotation from a book of the Cyberjustice Laboratory that I found in your website, A Tale of Cyberjustice. That it seems to me that it sum up the main poles of the balance. In the one hand, of course, the current existing procedure has many rituals and practices that have been enshrined, and most of them still meet many of the needs of the justice. So we have to keep them. At the same time, we have to have in mind that technology will not solve all the problems of justice. It's the problems that surround justice, the judiciary, are broad, complex, and only the technology is not possible with only technology tools to solve all of them. So at the same time, the current situation, it is a perfect moment or an excuse to rethink the judicial processes. So we are right now in a moment quite interesting, I think, to rethink some practices. So precisely in this context, I will move on to the second part of the talk. And of course, this one is referred to the videoconferencing that, as I said before, it has been, I would say, in Spain and in the most countries worldwide, it has been the king technological measure during the pandemic, of course, for obvious reason. In this sense, I would say one of the interesting experience that I have during this pandemic is to see that even though, or regardless the different backgrounds, legal, cultural backgrounds of each country, I have observed that almost all the countries during all the judiciary of different countries have faced similar kind of problems and have searched for similar kind of tools or remedies to those problems. So in the end, perhaps we are not so different. Even we include including systems of civil law and systems of Anglo-Saxon, the United States and United Kingdom, common law. I didn't remember the word. This countries with a common law and civil law, even though we are supposed to be so different, I think this pandemic has shown that perhaps the way we deal with our procedures and the way we have had to deal with the pandemic is not so different. And here we have the first proof, we could say, the way we have went to the video conferencing to try to keep going. So what is video conferencing? Very short. And we could say it's from in-person to remote. Of course, we all know that it's a tool that we already had previously. We used the video conferencing, but I think the main difference would be that right now we are asking ourselves if we have to go from the exception in the use of the video conferencing to the general rule, because we are now seeing that having hearings and trials through video conferencing have some benefits, undeniable benefits that we could use more broadly in the future. Which benefits? Some of them: avoid inconvenient travels and transfers, better use of public resources, and of course, time saving. But first of all, I would say we don't have to go crazy about using video conferencing in all the hearing. I think we have to probably apply this tool broadly in more cases, but not necessarily in all of them or in the majority. We'll see why. First, let's talk about platforms or tools through which we can use video conferencing, because of course there are a lot of different tools. Right now we are using Zoom. It's a good one for this kind of acts, webinars or talk. We could ask ourselves if a tool like Zoom is appropriate for a trial. Let's see which is the problem. That's why I would distinguish between serious video conferencing and private domestic video conferencing. The first one is one under public control and integrated into the judicial network. I'm afraid it's obvious that if in the future we are going to use, as a general rule, or in most cases, the video conference, it would be better to have a public system integrated into the judicial network system in terms of confidentiality, security, and so on. We will see those. And in the second kind of tools, we have the private domestic, Zoom, Skype, Teams, even Cisco WebEx. I've put Cisco WebEx quite apart from the private domestic because we in Catalonia, we have this system. Apart from the general video conferencing, we have the Cisco WebEx systems, and I've seen that other countries also use this, and I'm not quite sure if we can call it exactly private domestic. It seems to me that it has some more powerful security or a broader control by the public or the tribunal. That's why I put the Cisco WebEx in the last place. Let's move on. When we are facing video conferencing, I would analyze the video conferencing trials and hearings from a critical perspective, not because I'm not in favor of that, but because I think it's necessary to have this critical perspective in mind, precisely to be sure that we respect the rule of law and all the rights involved in a trial, in a procedure. I would say that the goal we should try to achieve, it would be the principle of fidelity. By that I mean to try to achieve that the video conferencing trial, it is as if the trial occurred in person, respecting and complying with all procedural and legal guarantees. That is the main goal. Probably it's not always possible, but we should tend to direct the direction. Which are the obstacles or the problems, issues facing this main goal? I would say, first of all, some kind of prerequisites. They are very important, are again quite obvious, but they are absolutely crucial, because if we don't have these prerequisites working, there is no hearing trial possible going on. First of all, the system must work, of course. The sound and image quality has to be of a high quality, or at least medium quality. If not, the trial is not, the judge will not be able to assess properly the proof, the evidence. The continuity of the signal, of course. This synchronization is crucial, because the trial or the hearing can become an absolute chaos. The bandwidth, of course, the previous prerequisites depends not only, but in part, on the bandwidth at our disposal. And in resume, that a fluid interaction is possible. And another question, or important question, that these prerequisites have to be present in not only for the court systems, but also for the internet connections or devices of all participants, be it the lawyers or even the citizens that are making a statement or giving a witness. So here are the prerequisites. Legal principles. of course, we have to, if we are using a so special tool like video conferencing, we cannot forget the legal principles that must be fulfilled in the highest possible degree. And this, I think it's important because from my personal experience, when I have a hearing with a video conference, sometimes there are so many technical issues involved that our purpose is only that it functions, that we can hear more or less the witness to comprehend what he or she has said, and that's all. We are happy because we achieved to celebrate, to have the trial finished. And sometimes we are so focused in hoping that no technical problems arise that we forget that the other legal principles that must be fulfilled. Which ones? Publicity of the judicial acts, confidentiality, related with that the data protection, right of defense of all the parties, the integrity and epistemic quality of the evidence. This is related to the prerequisites. Finally, the immediacy, the proximity of the practice of the evidence. It's important that all these legal principles are respected, and of course that they are not substantially devaluated due to a blind faith in technological advances. Right now, I think we see the video conferencing as some kind of magic tool. We had it before, but right now we see it as a magical tool, but we have not to forget all these legal principles and in the balance between the due process of law and the quality of a trial or hearing. We must give more weight to the second one. Here, I will make for the first time or the second time another distinction. I'm sorry because I am making quite a lot of distinction, but they are crucial to make it clearer. Between the hearings in which only participate professionals, mainly prosecutors or lawyers, and those, and the first one, we don't practice. There is no practice of evidence. And those in which we have practice of evidence, witness, experts, statements, and so on. They're quite different because we could say that in the first one, in which only professionals participate, we can, to some extent, of course, relax those legal principles. Actually, we can relax them because in those cases, they are not so at stake, because the question is if we can achieve the proper confidentiality and security of the hearing and the quality of the signal, it's enough for the judge and the lawyers to understand each other and to propose the evidence, admit the evidence, or to resolve some and decide some kind of procedural matter or issue that arise. As far as there is no practice of evidence, of proof, it's quite more easy to fulfill the requirements by video conferencing. So this is an important distinction. Another distinction, we have to distinguish between the traditional video conferencing, the one that we've been using until now, and I would say the one we are probably going to be using in the next future, that is the traditional video conference, that in which there is only a telematic connection of one or even more participants in the trial, but in the context of an ordinary face-to-face in-person trial. That's the traditional video conferencing. And the other one would be a full video conferencing trial. We could call it virtual courtrooms, in which all the participants perhaps except the judge, all the participants, professionals and citizens alike, are connected by video conference. In this case, I have to say that I must say that in Spain, although the video conferencing trials and hearings have been allowed, the judge has to be seated or celebrating or having the trial or the hearing in the judicial building, in the tribunal. I have seen in some other webinars, some of them by the very Cyberjustice Laboratory, that in some countries, in Canada, I think, some trials have been held with the judge from their home, so his or her home. So that has been not the case in Spain. But anyway, I would like to make this distinction because it has nothing to do with a traditional video conferencing and a full video conferencing trial. In this respect, I would say that in Spain, there is actually a general legal provision that in abstract could allow for full video conferencing trials. But they are so special due to the multi-channel signals that are required from the witnesses, from the professionals, the judge, that I'm afraid that we need a more complete and precise legal framework. Until we are not provided with such precise legal framework, it would be difficult for us to have this kind of full video conferencing trials. In the meanwhile, of course, not having this legal framework, the tribunals, what they are doing is to search the agreement of all parties to have this kind of video conferencing trials, hearings, and when the agreement is reached, so they have been possible. Here I would like to make a short reference to the Cyberjustice Laboratory, because when preparing this talk, I entered the website of the Cyberjustice Laboratory, and I saw this software, ISA. This software module is a kind of a courtroom, digital courtroom with video conference and computer and audiovisual tools. Here we can see all the participants, témoin, l'avocat, le juge. I must say right now that I'm learning French, and I have seen some webinars and talks from the Cyberjustice Laboratory in French, and they have been quite useful to learn some French vocabulary. So I close this commentary, and let's go back to the ISA. I put it here because I think that when in the near future, we may have some kind of entire video conferencing trials, I think that the software needed, it will be quite similar to this one. So if someone is interested, can consult this tool in the Cyberjustice Laboratory. So let's move on. The principle of publicity in the context. I insist in the context. We are always in the context of the video conferencing. The principle of publicity, public audience, it's a very important, crucial principle, because without it, we could not have a democratic judiciary. It's obvious. So we may ask ourselves how it's not easy to answer this question. How we deal with the publicity principle when we are using video conferencing? How the public must be allowed to see the trial, the hearing, in another differentiated judicial agency where they can observe it in closed circuit with a password or invitation, like we are right now having this Zoom talk. Could we apply a general internet broadcasting for all the trials? It seems quite challenging, but there have been some cases in Spain and other countries that trials of special public interest have been broadcast over the internet. So in those cases, we have to ask another question that arises immediately. Shouldn't we have to apply measures to avoid clandestine recordings? It is necessary to establish a prohibition to obtain copies of the session or not? Is it possible for the software to prevent recordings by users' invite? Or there is no problem with all those users making recordings? I think it's not so easy to answer this question. Confidentiality, it's the same. Let's move on. Here we have I think a crucial matter, a crucial point. Is the right to defense. I've seen that I've been talking for 45 minutes. I will go faster if necessary, but if I don't receive any contrary signal, I will continue. I think here we have a very important principle or right to be respected in video conferencing. Is the right to defense, especially when the lawyer and accused in criminal cases are in different places. The accused must always have the possibility of maintaining a permanent and reserved contact with his lawyer by electronic means. Reserved, that's crucial, of course. The same goes with, in case of police detention, a reserved interview, police detention in which the hearing to decide of the liberty or the detention or the preliminary detention in this kind of hearings by videoconferencing. Videoconferencing must be allowed the person in detention to have a reserved interview with his or her lawyer. Here we could talk about of the breakout rooms for confidential counsel in the context of virtual platforms. Another question that arises. Let's move directly to the point C, third point. When, as I told, there is a huge difference in video conferencing hearings, trials, in which evidence is practiced, like party statements, witnesses, expert declarations. Which is the place of the declaration in those kinds of video conferencing trials? A judicial facility closer to the place of residence of the witness or the expert, or even from their workplace or their own homes. Even we could imagine from the street through a mobile device. Are we going to accept this kind of hearings? In those, if we do, how can we be sure that the witness in any of those cases isn't told what to say? Because of course, that's a key point. A positive perspective would be the access to justice, because in certain cases of vulnerable people with disabilities or similar, a remote video conferencing supervised by the judge may allow a greater access to justice in those cases. But as a general rule, it seems to me that when we are dealing with witnesses, with experts, especially with witnesses, a lot of doubts arise. Another question, very important, especially, not only, but especially in the civil jurisdiction, documentary evidence in a video conference hearing context. Here we could have some suggestions. It would be useful to provide the documents to the tribunal in advance. Of course, it is necessary the accessibility to the parties' lawyers for viewing and eventual downloading the documents. Here, there is a precision, important precision that must be done in the sense that there has to be the possibility to exhibit to the lawyers the document, but only exhibit it prior to the decision of the judge admitting or not the document. And only downloading, allowing the lawyers, the parties' lawyers, allowing to download the document when the judge has admitted the document. So there would be two phases, the mere exhibition and the downloading. So they are quite different, and it's important that a party cannot download a document that immediately is refused, is not admitted by the judge. It's quite important. Another suggestion, hyperlinked indexes to facilitate in the documents to facilitate their use during the telematic session. Here, security. So other suggestions, they are quite as in the Zoom talk that we're having right now. There should be waiting rooms to ensure that only authorized persons are connected at any time, especially separate virtual waiting rooms for witnesses before joining the hearing, because of course in in-person trials we have to take measures in order to the witnesses. They cannot talk each other before they make their statements. So this should remain so in a virtual hearing trial. Of course, most importantly, the possibility to silence attendee and of expelling an assistant, like as in a normal trial. Let's move on. Here are quite some funny suggestions that I have found in a document called Best Practices for Remote Hearings. It's quite new. It's in May, I think, or March. May, I think it's March. It has been written by these four agencies. Suggestions, best practices. Participants should not move away from the screen or turn off their cameras during the hearing. Of course, it is crucial that the judge can see the participants, especially the witnesses, and that he or she can see them all the time without any interruption, because if not, there would arise doubts regarding the integrity of the proof, the evidence, to understand each other if some third party has put in contact with the witness. The usual restrictions on eating and drinking in a courtroom apply. This is a best practice, of course. Only water should be allowed. And another funny one is it necessary to stand when a judge joins the hearing or when addressing a judge? Is it necessary for the witness, the parties, to stand when a judge virtually joins the hearing? Of course, in those countries where this remains a custom. So I don't think it's a good idea, because we can imagine some witness, some lawyer that having dressed properly in the top half of the body, we could imagine that in the other half of the body, it's not the same kind of proper dress. Then in this case, if he or she had to stand, we could have some problem in the way of dealing with the evidence or with the trial. I'm finishing. Last remarks regarding the evidence assessment. I think they are quite important in a video conferencing context. Is the immediacy principle at stake in terms of assessment of credibility? Of course, it is crucial that the judge has this direct and frontal interrelation, this proximity, the absence of intermediaries, a bilaterality between the judge and the evidence is looking or listening at. And this immediacy is the prerequisite for other principles like the contradiction, orality, and concentration of the proof. Here we have entering some kind of philosophical field, we could say, legal philosophical field, in the sense that sometimes there's some scholars that think that, or practices, professionals in the judiciary area, that think that it is crucial the in-person relation in a witness statement, for instance, because the judge must have the possibility to analyze the behavior of the witness, because this behavior tells us something important about the testimony in terms of credibility. And I think it's quite true that in a virtual or video conferencing context, the behavior of the witnesses may change and may be not so direct, we could say. But at the same time, there is in the other pole of this reflection, the fact that the value of behavior evidence that we normally or usually give to the way the witness behaves, in the sense that this behavior tells us something important, the very value of this behavior evidence has itself been seriously questioned. So we have all heard about professional lying witnesses and so on. Perhaps it's not so important, this possibility to look directly at this behavior without an intermediate of a video conferencing tool, technical tool. Let's move on. Another, I would say, more philosophical question, but it seems to me quite interesting. It's interesting. I haven't read these reflections in this paper of Amy Salizin, A New Lens, Reframing the Conversation about the Use of Video Conferencing in Civil Trials in Ontario. It seems interesting to me, this reflection about to which extent the physical geography of adjudication, of deciding a case, is relevant. To which extent, if we disrupt this geography, because of course, if we go from an in-person hearing to a video conferencing hearing or trial, we are disrupting absolutely the physical geography of this adjudication. So to which extent does it threaten the solemnity associated with, and also the respect given to, the civil justice system? Is there any kind of threat here? Because we can deny that the fact that having a trial in the official facility, in the courtroom, it has some power effect that reinforce the importance of the trial. If we go to a video conference trial in which the witness is making his or her statement from his home or from the street, we can lose some formality that attaches to the ceremony that always has been the trials. So to some extent, if we generalize to some extent the use of video conference, I think we should infuse, as I put here, infuse the remote location with some of the gravitas. I like this word, some of the gravitas that can typically be seen in a physical courtroom. We should achieve this balance between flexibility with a video conference, but maintaining some kind of gravitas, because we are still dealing and having a public trial. Another question, it's really interesting. Here there is a quotation of Henri Lefebvre, in the sense that the space is not a scientific object removed from ideology or politics. It has always been political or strategic. This is interesting because, of course, having the trials in the official public courtroom has a political and a strategic meaning. We can deny that, because reinforce, as we can read here, reinforce, as this scholar, the unequal power relations and marginalized vulnerable individuals. Going beyond that, here Mulcahy makes a interesting reflection in the sense that the location itself, or the allocation itself of people in the space has a coding effect of their reciprocal relations. And in this sense, it's interesting because there are studies, empirical studies, that reflect or demonstrate to some degree that precisely having a witness to go to the courtroom, the physical courtroom, and give his or her statement in front of the judge in the courtroom may make it difficult to be sincere and confident. So here we have a paradox. While we could say that moving from the courtroom could have some problems in this sense, at the same time it could have these benefits in the sense of the witnesses appearing more confident. So it's not an easy question. So in this sense, we could talk about a liberating potential of the video conferencing, in the sense that to broaden the possibilities of making statements of the witnesses, and mitigate these political and strategical and effects or consequences. As I said before, here we have the reinforcement of unequal power relations and marginalized vulnerable individuals. The mere fact of allowing certain vulnerable individuals to make direct contact with the tribunal by video conference may have this liberating potential. So anyway, we have to have in mind that the video conference is a practical tool, but not a neutral tool at our disposal. We have to be well aware of the implications in all the sense that we have seen. And finally, I've been talking about an hour. I would like, if possible, I would like to make some few remarks of the third part of my talk. It was intended to be short, so there is no problem. So if I don't receive any different order from the host of the talk, I will go forward, but I promise, very short. Here we have, I will talk now, suggested improvements for the future. More concrete, some kind of digitization, or some kind of artificial intelligence tools. Here I'd like I'll make another quotation from A Tale of Cyberjustice, because here we have a different distinction between 3 ages of digitization, or we can also say, I think, digitalization. The first age, this mere fact of digitalize the existing court processes. So here we would have the same as we have had before, but in a digitalized form. The second age, the creation of new procedural models, precisely using the new technologies. We in this way, create a new procedure. And the third stage would be, of course, the use of specifically artificial intelligence tools in some cases. I will go fast. These are these three phases, three ages, sorry. Here, I would like, if someone is interested, I give here you this document, the reference of this document of the European Commission for the Efficiency of Justice, guidelines on how to drive change towards cyberjustice. It is a compilation of I would say, all the digital measures taken by all the European members, European countries of the European members of the European Union. I won't analyze all of them because you can read them. It's interesting to see that the case management, it has been the first area to be computerized in the sense of electronic signatures, the e-filing of claims, summoning, powers of attorney, digital payment order procedure, all is the first area that has been digitalized. The templates, the databases. Here, it is interesting, I think, make one remark in the sense that nowadays the databases used by the tribunals, the public ones, there are private ones, but the public ones are frequently open to all public and free. And this makes some point of democratic advance in the matter. But an important issue here would be the neutrality of the consultation criteria, because we don't have usually all the decisions, the rulings that are issued in a country, in a judiciary system. So the criteria through which we decide which rulings are in the databases and which are not are crucial, because there is a tendency, the higher the court is, the more favorable for the powerful banks and so on the rulings are. This is a general rule. So we used to find more progressive and challenging rulings in the first instance tribunal. So if these kind of rulings don't reach the databases, so that would make a non so neutral database. Let's finish with a very short reference to artificial intelligence. Here, when we talk about artificial intelligence and the judiciary, frequently we think about robot judge, but I would emphasize more some tools that we could call automatization or automation of some repetitive tasks. In the tribunals, we have a lot of repetitive tasks, and I think in some cases, we could use artificial intelligence tools if they were available. Here, I will give some ideas, because sometimes when we talk about artificial intelligence and the judiciary, we make general statements, but not concrete or precise proposals. Here, I make some propositions. I don't know if they are any kind of possibility to be getting enforced in the future, but in the deanship of a tribunal, detect the type of procedure of the claim and the apparent complexity of the case, to see, for instance, the volume of work that will require solving it, in order to take this into account to articulate a more equitable distribution of the cases between the tribunals. Jurisdiction, some kinds of issues about eventual lacks of territorial objective jurisdiction. I think they could be automated in some kind of cases, because they are not quite complicated. Here, in control clauses, especially in unfair clauses contract, some tools to identify each of the relevant clauses so that the judge can get there immediately to analyze them. That's important because as frequently we have a contract with a very small characters. It's very difficult to identify and localize the clauses we are searching. So some kind of tool to identify. Even we could ask ourselves if it is possible a tool to automatically detect the very existence of unfair clauses. In some cases, for instance, the default interest in which the legal criteria that makes this clause unfair or not or fair.
Hi, so we have a couple of questions. The first being, in a courtroom, having a public allows also to build an emotional and more human environment that can sort of influence many aspects of the trial. The lawyers should gain the emotional support of the defendant or the victims, having once they're in court, the building of a cause in trials related to human rights, the decision of the judge to fix the sentences. How do you think virtual trials would change it? You have talked briefly about the solemnity of traditional trials. Can you elaborate more?
Okay, thank you. Can you hear me?
Yeah.
Yes. First of all, I'm so sorry because I've had some internet connection, I think, problems. I'm not so sure until which minute there has been connection, but anyway, I'm so sorry, and I will try to answer this question. Of course, as if I have understood well, the question refers in general or in family and child cases?
The cases you are familiar with.
Okay. Of course, as I mentioned in the talk, this is one of the main challenges in the video conferencing assessment of proof of evidence, especially regarding witnesses, because I would make a distinction between if it is a party that is making a statement. Here, there is no so huge problem because normally parties make statements that are good for themselves. So here that is not crucial. I don't see a lot of problems neither in the expert's witness, because what we are trying to achieve with an expert witness statement is to clarify, to develop some points of his inform his study. So the problem is with the witnesses. A funny thing right now with the pandemic, I have read some papers from scholars that suggest that it's not so important to hear the witnesses, because we all know that all or almost all the witnesses lie. And if we are not able to have in-person hearings with witnesses, it's not so important. We in civil cases could go directly to the documents and to the experts. I don't think it's quite the case. It's important to, of course, in some cases, it's important to listen to the witnesses. And here, I think I said that in the talk, but I must confess that when, at least until now, when I have a video conference witness, my objective, my goal is to cross my fingers. I hope that there is no any technical issue, but it's quite frequent that there are technical problems that make it difficult to hear, to see the witness. Sometimes, frequently, the image is quite far from the witness, so you can't even see the face, his or her face, which are the reactions of the witness. But I insist, we in those cases are so preoccupied with the technical issues that we even we don't give importance to the fact that not being able to see the face in more detail. And that's why we should have in mind that if we create in the near future, or right now, some kind of virtual platform to have hearings, it is crucial that who is talking, as right now, Zuiji, I can see you, your face, I can see you quite well, is enlarged in the screen and with quality, image quality, and is it possible to see these details of the answering, of the statement of the witness. On the other hand, I think I told that it's true that we have a paradox here, because perhaps the witness being at his or her home is more sincere, is more relaxed, is not so impressed by the presence of a judge with a rope and so on, and perhaps we have a more interesting and fruitful statement. So we have, it seems to me that we have not to be dogmatic in that question. We have to be open-minded, and firstly, to have all the technical requirements and the quality of the image and sound available.
Thank you. So maybe one related question. You mentioned earlier that in Spain, the courts are giving priority to video conferencing for trials and urgent cases. What are some of the criteria that you or other courts use to sort out the type of cases more conducive than others to a remote hearing?
Yeah. Until the pandemic, of course, the criteria was, we could call it traditional, in the sense that we had video conference in cases in which the party, the witness or the expert had the residence far enough or without the proper public communication. This was the main criteria. And that's why it was exceptional, the use of video conferencing. And I think it was exceptional due to the frequency in which we had technical problems. So we had even though we have the technology, the necessary technology in the courtroom, it is important to have in mind that it's not only the court system that must work properly, but also the video conference of the other tribunal in which the witness is making his or her statement. So because of that fear of technical problems, we had a very narrow criteria for using video conferencing, only when it was the residence very, very far. Right now, I think that right now with the pandemic and the more broad use, more general use of video conference, we are realizing first that this technology has improved. So it's not the same, the problems we had, I would say 5, 6 years ago than now. Now it works better. So this kind of problems are few. And on the other hand, of course, the health emergency has proved or make it more intelligent or more profitable to use this video conferencing. So it seems to me that right now and in the near future, the criteria will be: 1, hearings only with professionals. I mean, without practicing of proof or of evidence, without witnesses, experts. It seems to me that we will generalize a lot, if not always a lot, in these cases, because in these cases, there are not the principles of legal due process and other principles that we have been talking about during this talk are not at stake. So while we have a proper, secure and the quality signal, we can maintain this hearing. So I think we are going to have a lot of these kind of hearings only with professionals. And on the other hand, in case of witnesses and experts, I'm afraid that we will remain quite skeptical or restrained, narrow in these cases. And especially, of course, if we are talking about criminal trials, they are always going to be in person, unless, let's hope it's not the case, unless another pandemic or similar situation like the current one occurs.
Thank you. We have another question that just came in on the political strategic dimension of space, which you mentioned during your talk. What do you think would be the impact of being at home instead of the courthouse? For our homes as spaces have also a political and strategic dimension. How could this influence how the participants' claims, evidence, etc. is perceived? What could be done to limit this influence, if there is any?
Yes, this political dimension of the physical placement of the hearing, I think it's quite interesting perspectives to analyze the video conferencing, and it's not the one usually addressed by scholars when writing about this tool. So I would distinguish two problems or two dimensions in this in the sole idea of having a witness declaring from his or her home. First of all, is a more technical one. Is the following: how can we be sure that he or she is not being told what to say? And this could happen through a variety of ways. First of all, it could be one person besides or at the other side of the computer that the judge can see, who is telling him or her what to say, or with a mobile device. If I have here my mobile, if I put it on the table, you as a judge, imagine you were a judge, so you could not see if I'm looking at the mobile, and if my lawyer or another witness or whoever it may be is telling me, don't say this because a previous witness has said something, and if you say that if you maintain this this way of things, of the facts, there would be a contradiction and our case goes down. So this is the first problem. I think it's the main reason why I think that we are not going to generalize video conference when it comes to witness evidence. Perhaps we could make a difference in cases of parties' statements, because they are not so crucial, they are not so delicate, and expert witnesses' statements. But in witnesses, there is this problem. And here we have one. And the other one, coming back to the political perspective, it seems to me that we could say that it has a democratic potential, in the sense that for a witness to make a statement, it's not necessary to go through the public building, to pass the security control, to have to ask where is the courtroom, to enter the courtroom and see all the scenario you always find there. Perhaps, as I said later, this could lead us to a more sincere statement. At the same time, we have to achieve and to not banalize what is having a trial, and to maintain the gravitas, as I said. It's not easy, because if in this regard, it could be a good idea to have some list of good practices, as we saw later, not later, before, to pass them or to write them down in the summon or the citation to the witness, in order that he or she is aware that when he or she is declaring, making their statement, have to fulfill some requirements. In regard to, we could say, how you dress, what have you available to your vision, and of course, the fact that the screen is what is to be seen by the judge, and the continuity not to cut the image and so on. So it could be a good idea to attach with the citation these best practices. And at any time, this would be a risk, but at any time that in a witness some of these best practice or requirements is not fulfilled, it could be a reason for the annulment. If we are dealing with a material witness, an important witness, it could be a reason for the annulment or the ruling, the procedure. So we have to be very precise with this kind of questions.
Thank you. We have got a final question. I was also interested in what you said on ensuring fluidity of communication, and especially on having a good connection for every person on the procedure. How would you implement this? I'm thinking about vulnerable people, remote places. What can be done in cases where this problem cannot be properly addressed?
Of course. We could distinguish those cases in which we have, in principle, good connection, but during the trial there is a problem and the connection fails, as occurred to us a few minutes ago. So imagine if that had happened during a trial. No? This would be a case, and the other, as I'm fear you are questioning, the cases in which a vulnerable person has not the means, the technology required to make the connection. No?
Yeah.
Of course. At any time, it must be preserved. One of the most important principles is the equality of arms. So especially if we are dealing with a party, if the vulnerable person that has not access to this required technology is a party, so here arises with all its strength the principle of equality of arms. So we must find a way to allow this kind of video conferencing. Again, if the party has not at its disposal this technology, but his or her residence is not quite far from the tribunal, and at that moment there is no pandemic like the current one, the best solution would be to this party to go to the court and have an in-hearing trial or hearing. If that was not possible, for instance, because the vulnerability is a person that has not the capacity of moving to travel to the tribunal, we could think, I don't know, but we could think of, I'm thinking right now, in the moment, we could think of some public points, judiciary public points, in which this kind of technology would be available to the people, vulnerable people or people without this kind of technology. And they should be not in the main cities, because if you live in a big city, of course you can go normally to the tribunal and have an in-person hearing. But we could think about public points, public technological points with all these technological resources in small cities, in order to allow these people to go there if they have their residence in that supposed small city or town, and have this video conferencing. So of course this should be granted by a public budget and so on, but I think it could be a quite good idea.
Thank you, Mr. Soler, for this very informative presentation. I don't see any other question coming in. I will turn it back to my colleague Helen for any other additional questions she may have.
Yes, thank you, G. You mentioned that right now, in this pandemic times, there is no budget that is being allocated for all of the measures that have been taken in the short term. In general, is there a budget for the modernization of the judiciary by technological means in Spain? Is there any kind of program that has been implemented in the past few years to bring justice to a more modern times?
Yes, of course there is a budget, but the question is, I'm afraid that this is quite the same in many countries, that the judiciary is not the first goal of the politicians to apply the big budgets, public budgets, because you don't gain many votes spending public money in the judiciary. So this is a structural problem. That being said, of course, there is a budget. Here in Spain and in Catalonia, there is another circumstance that make it more complicated, in the sense that we have, on the one hand, the General Council for the Judiciary that deals with the measures regarding only judges. Then we have then we have the central government that deals mainly with the clerks, and in some areas or regions of Spain with the rest of the officials of the tribunals. But there are many regions, like Catalonia, where is located Barcelona, in which the region is responsible for especially the material means and the technological means. And in this sense, of course, there is a program. We have at our disposal technological means, the video conference, the digital the procedure has reached a digitalized level, I would say quite relevant. Actually, I may confess that until 4 or 5 months, I was a quite traditional judge, in the sense that I like the paper, I like to see the files, to touch the files, and I didn't like to deal with the cases through the digital environment. Right now, with pandemic, we've been obliged to work from home with the laptop and with a special security connection by internet, with the judiciary network. And I must confess that I can say that the level of digitization of the case management here in Catalonia, because this system applies only in Catalonia, because it's it's a responsibility of the regional government, is quite developed. The problem we have faced is what I mentioned earlier, that the officials that make the first step in the procedures, they don't have this special laptop, so there has been quite a proliferation. But I would say that the digitization level is quite high, especially if we compare it with what it was 5 years ago or so.
Thank you. I have a last question. So you mentioned changing your mind about bringing more modern technologies into justice about 5 months ago. So why were you resistant to it before? What made you change your mind? And what do you still notice in terms of resistance in your colleague and in the whole justice system?
Well, this it becomes to seem a confession, this, but let's move on. Yes, I'm afraid that it's this kind of conservative feeling or perspective is quite general in the judiciary. I mean, when some kind of way of work has been established in the judiciary, it is too strong, and it is very difficult to change. I don't know why, because because perhaps the judiciary, with the members of the judiciary, are conservative in this respect, and we are reticent to make changes in a modern way. Why? I would say these conservative perspectives and the fear of changes, because of course when you have to change your way of work, there arise some challenges, questions that may perhaps make it's more difficult to make this step, no? But I must say that after some month working with the laptop, you can see a claim that has been e-filed. You can see the notification to the other party, to the counterclaim. You can see all the statements of the parties, and you can write your ruling in your computer. You can send the ruling to the judiciary network, and it may be served to the party. So really, I think we can already say that we live in a digital world, and the step of, or the level of digitization, as I distinguished in the first place, we can deny it, and the benefits are so obvious. I mean, the digitization that we have to use, there is no excuse. No, I don't see any excuse. Another question is, it goes the same with the video conferencing in trials. I think we have to be more cautious about that, and we have to be the same open-minded with the artificial intelligence tools. We have to be even more cautious here. But in terms of digitization, there is no doubt. We have to go in that direction. And as I mentioned, in Catalonia, we have right now at our disposal a relatively high degree of digitization.
Thank you for your answer. While you were answering, another question came in from the audience. So someone is asking if you know about the Brazilian electronic process, and if you do, what do you think about it?
Brazilian?
Yes.
Yes. I'm not sure if the participant that is asking this question is referring to some artificial intelligence tools that are being used already in Buenos Aires. It's possible. If that's the case, I'm aware of that. They are quite pioneering this kind of use of artificial intelligence in the judiciary. And actually, I read in an article or in a news, I don't remember, that the General Counsel of the Judiciary of Spain is also interested in what are in the tools that are using in Buenos Aires, and they travel there to know what they are doing, and I suppose to analyze if is it possible to transfer in some way that to Spain. In fact, I saw one video in YouTube in which they presented these tools. I don't remember which were the name. Well, it's like a chat box, but a chat box not for the citizen, but for the official of the tribunal. It's the official of the tribunal that puts in the chat box the number of the file, then answer some questions, and in a very few seconds, actually, it comes a template or a ruling or a decision that may be used for deciding a case. It seems to me that, of course, they are using this kind of tool not in complicated cases, but in rather repetitive tasks. Actually, it seems to me that this is the key point. I think that it would be interesting to analyze if it's possible to use some electronic and artificial intelligence tools to apply in some repetitive tasks that we deal with in the tribunals, because there are quite a lot of them. And we spend a lot of time with them. They are not so complicated. Actually, they used to be quite easy, but we have to deal with them. And if some kind of tool, not a tool that decides the case, of course, but that supports the judge's tasks, we could save quite a lot of time in that kind of repetitive task and have more time of course, to attend more complicated cases and so on.
Thank you. On that note, I think we've answered all of the questions from the public. So in conclusion, I would like to begin by thanking you again. I'm sure your schedule is very busy at the moment, so thank you for accepting our invitation. Thank you for the very interesting presentation and all the research that you carried out in preparation. Thank you for sharing all this knowledge with us. I would also like to thank the public for their participation and for all of their questions. Take care of yourself and your loved one. Thank you again and have a good day.